Rule 77. Allowance of will proved outside of Philippines and administration of estate thereunder. Section 1. Will proved outside the Philippines may be allowed here. Wills proved and allowed in a foreign country, according to the laws of such country, may be allowed, filed, and recorded by the proper court of first instance in the Philippines. Rule 77, Section 2. Notice of hearing for allowance. When a copy of such will and of the order or decree of the allowance thereof, both duly authenticated, are filed with petition for allowance in the Philippines by the executor or other person interested in the court having jurisdiction, such court shall fix a time and place for the hearing and cause notice thereof to be given as in case of an original will presented for allowance. Rule 77, Section 3. When will allowed and effect thereof. If it appears at the hearing that the will should be allowed in the Philippines, the court shall so allow it, and a certificate of its allowance signed by the judge and attested by the seal of the court, to which shall be attached a copy of the will, shall be filed and recorded by the clerk, and the will shall have the same effect as if originally proven and allowed in such court. Rule 77, Section 4. Estate how administered. When a will is thus allowed, the court shall grant letters testamentary or letters of administration with the will annexed, and such letters testamentary or of administration shall extend to all the estate of the testator in the Philippines. Such estate, after the payment of just debts and expenses of administration, shall be disposed of according to such will, so far as such will may operate upon it, and the residue, if any, shall be disposed of as is provided by law in cases of estates in the Philippines belonging to persons who are inhabitants of another state or country.